Delegate Cardin, please don't swear at traffic.
We're live.
Great. It is February the 11th at about 4:30, and this is the House Judiciary Committee. We're going to be hearing 5 bills this late afternoon and probably not early evening, but we'll find out. It'll be exciting. And we're going to begin with Delegate Davis's bill, House Bill 580. She has several witnesses, including Charles Harper, Stacy Bensky, Christopher Dews, and Dan Hatcher. There are several other people who wish to testify as well on the bill, but we'll go ahead and do that first panel of 5, each with 3 minutes for the sponsor, 2 minutes for everybody else, and then we will go from there. All right, so Delegate Davis, if you would like to get us moving. Thank you.
Thank you, Mr. Chair, Madam Vice Chair, colleagues on the judiciary. I'm here to present House Bill 580. We're revisiting suspension of child support again, suspension of driver's license and child support arrearages again. And in response, let me start from my speech here. I am concentrating on the criminalization of poverty, generally incarcerating people based upon their inability to pay a debt. I think this is especially important since our founding fathers expressly forbade incarceration for debt. And over time, we found several ways to get around that. I submit that it's unconscionable, especially incarcerating people and having severe fines because they can't pay debt. I believe it's unconscionable, especially when the person can exhibit proof that they cannot pay, especially when the law does not deter and sometimes exacerbates the problem. So I submit to you that in response to some of the criticism that we've gotten on the bill, we have submitted some amendments, and the bill as it would read now with the amendments would just carve out an exception. The exception would be that a person who's 300% under the poverty line could not be incarcerated and could not be suspended. I think that's an awesome first step to making a big difference in removing the criminalization of poverty. And I submit to you that this is a great first step, and I respectfully request a favorable report for HB 580. Thank you.
All right, so let's go now go to Charles Harper from JOTF. Mr. Harper, are you there?
I'm here. Can you all hear me?
Yes, we need to see you though too.
All right. I'm currently picking up my son from daycare. I can turn on my camera.
That's okay. You've seen a lot. It's okay. You're all good. That's fine.
All right.
2 minutes.
I'm good.
You're good.
All right, 2 minutes. Thank you. Thank you so much. All right. Good afternoon, Chairman Smith and members of the I'm here for
Charles, you were doing really well until you started, but we're going to let you start again because I think you broke up there a little bit.
Okay, cool. Can y'all hear me?
Yes, we can hear you now. Go ahead.
Cool. Good afternoon, Chairman Smith and members of the Judiciary Committee. My name is Charles Harper. Can you hear me?
Yes.
Okay. Members of the Judiciary Committee, my name is Charles Harper. I'm here before you all to testify on the effects of driver suspension due to child support policies that take place among working class citizens such as myself. I have a son who just reached the age of 12 and is getting ready to turn 13 in a couple of months. I currently pay $383 a month under my child support order and have a total of $4,000 in unpaid arrears. I understand the severity of these fees and take full accountability to support my son. However, I believe the system could take further factors when determining ramifications and obligated waste. I believe one of the biggest non-considered factors rests in the lack of support and education the Child Support Administrative Office offers. Most victims of this system are uneducated or the lack of resources needed to get help. Filing specific documents or acquiring adequate representation plagues fathers and mothers in the U.S. I personally withstood a horrible experience upon creating a formal agreement. Yet, after alterations and problems were explained in advance, I might have sought an attorney or legal counsel. No one mentioned how important money orders could be, receipts, or videos for that matter. I take care of my child, whether it can be proven in court or not. I also believe that there should be another form of assessment when the case to see if the plaintiff actively is a part of the child's life. The system is transformed from finding solutions to growing welfare costs to a method of securing federal fundings. We should transition back to the origin of the issue and ask ourselves, are people not taking care of their children or are parents filing for benefits? There are many factors outside of what child support calculators or any assessment can attest to. I do not believe in the specific consequences of driver suspension. This creates an issue with me personally, but a bigger issue with countless other hardworking individuals. For myself, I cannot be able to see my son as often or at all due to his location. This also creates a problem for my transportation to and from work, which will affect the amount I can contribute to my son, not to mention workers who drive for a living. Nevertheless, it is for these reasons I am in favor of House Bill 0580. And I thank you all.
Thank you. Thank you very much, Mr. Harper. All right, we'll go now to Stacy Bensky if she's here. There she is. Ms. Bensky, you have 2 minutes.
I did it.
Okay, am I on mute? Okay, sorry about that. I was
You're
muted.
unmuted. Mr. Harper, you need to mute yourself. We'll figure that out for him. Ms. Bensky, go ahead.
Okay, thank you for having me testify. And a special thanks to Delegate Davis for the invitation. I'm an attorney with Maryland Legal Aid, and I work with family law clients with child support issues. With the proposed amendment, this bill would, in theory, accept obligors below the poverty level from license suspension for child support arrears. While Maryland Legal Aid wholeheartedly agrees this is necessary to help stop the cycle of poverty, without a change to the automatic license suspension system used by the Child Support Agency, this bill will do very little to stop license suspensions for Maryland Legal Aid clients and those below the poverty level. 10-119 of the Family Law article already has exceptions for obligors with disabilities and obligors who are paying on their arrears per an agreement or court order. But the automatic license suspension system, which is a random lottery of all obligors with 2 months or more of arrears, does not comply with 10-119 and operates as though those exceptions do not exist. For example, my client, who's 62 years old and worked most of his life at Bethlehem Steel until he became disabled, despite paying his child support as best he could, he still owes arrears for his now adult children. His disability benefits are garnished every month to pay off his arrears through earnings withholding order. So he falls under that exception in 10-119, yet he is continuously referred to the MBA for license suspension. And each time I have his license reinstated, a few months later, he receives another notice. He also helps his adult children by caring for his grandchildren, and he has frequent doctor's appointments. Now, these everyday activities become difficult when his license is suspended. This random automatic system does not work and disproportionately harms those who are disabled and living in poverty. This is easily remedied by suspending licenses only when appropriate and on a case-by-case basis, like suspension of professional licenses or recreational licenses. The controlling federal law says that the agency has to have the authority to suspend or restrict driver's license, professional licenses, and recreational or sporting licenses in appropriate cases. However, driver's licenses are the only types of licenses suspended by an automatic system rather than on a case-by-case basis when appropriate, as the federal law says. So,
Ms. Bensky, if you would wrap up, please.
Yes, very much. I'm finishing right now. Sorry about that. While we support the intent behind the bill, this amended version of the bill does not go far enough to help Maryland Legal Aid clients. And thank you so much for your time today.
Thank you. We will go now to Christopher Dews for two.
Perfect. Good. Yes, you guys can hear me, correct?
Yes.
Indeed. My name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force, where our mission is to help lower wage workers advance to higher wage positions. JOTF supports House Bill 580 with the 300% federal poverty line amendment as a means of repealing the punitive practice of driver's license suspensions for lower income workers. As many of you already know, Maryland is an extremely regional and mobile economy. The U.S. Census Bureau reported that 50% of Marylanders travel outside of their county for employment. Now, this was pre-pandemic, just to be clear. The statistic is more pronounced in lower income communities of color, where a scarcity of jobs is available by public transit. In fact, 9% of jobs in Baltimore can be reached within 1 hour by public transit. Thus, for economic sustainability, both a valid driver's license and a vehicle are necessary. In 2015, NPR reported that 62% of Marylanders who owe child support make less than minimum wage, but owe about $10,000 at least in unpaid arrearages. They're not going to be able to pay down this debt, and they won't be able to pay down this debt ever if we continue to allow the suspension of licenses as is allowed in Family Law 10-119. I understand that the way that this law is designed is to conform with federal statutes, but the way federal statutes are actually designed, it says that that the state should be able to suspend in appropriate cases that will, and to be clear, increase the effectiveness of the child support program. Suspending driver's licenses for lower income workers who don't have access to employment or are trying to seek employment and are now being denied employment because they don't have a valid driver's license benefits neither the custodial parent, the non-custodial parent, the child support administration, or anybody else who's involved in this transaction. As Charles Harper already mentioned from my organization, non-custodial parents do a lot more for their kids than I guess the child support system will actually acknowledge. And by that, I simply mean that the custodial parents don't necessarily want the license to be suspended. It gets in the way of them being able to bring in income, and it gets in the way of them being able to actually take care of the child, which is the point of paying child support in the first place. So this bill, we believe it'll be tremendous for allowing lower income workers to actually gain access to employment. I worked in workforce for a very long time. The number one barrier to employment when I was in my training program and at Project Jumpstart is a suspended driver's license. If we can repeal this for lower income workers, allow them to go to work, use the mechanisms like wage
Mr. Dews.
on the books, then we can see a much brighter tomorrow for lower income workers. For those
Thank you,
reasons,
Mr. Dews.
report. Thank you for your time.
Thank you very much, Mr. Dews. Dan Hatcher, please, for 2 minutes.
Thank you to the entire committee for this opportunity. My name is Daniel Hatcher. I'm a law professor at the University of Baltimore. I've done advocacy for, written about, engaged in scholarship regarding impoverished populations for almost 25 years now, including a good amount of advocacy around these issues of child support, both direct advocacy for custodial parents and non-custodial parents and children. What drives me in my research is really ultimately about what's in the best interest of children. I support this legislation strongly with the amendment at the 300% poverty level. That amendment would bring the legislation into compliance with the federal law. I know under the fiscal note and some prior discussion, there were some concerns. The actual federal statute gives a lot of leeway to states. This section of the Social Security Act, it says that there needs to be some authority to withhold or suspend licenses, procedures under which the state has and uses in appropriate cases. So this language, inappropriate cases, gives a lot of flexibility to a state to ensure that its program is hopefully not harming custodial parents, children, and the non-custodial parents. So this bill would actually lead to an increase in child support payments, right? Because for low-income obligors, I've seen no evidence that the license suspension program is helping increase payments. It's reducing the ability to work. And to all the other issues that we talked about in addition to working to help custodial parents care for the children. Another logistical problem that happens with the current setup, especially with low-income obligors, are that most will start off their order already with arrearages, right? Because once there's a complaint filed, a petition for child support, it often takes several months for it to actually get before the judge to result in a court order, right? So the order is retroactive to the time of the complaint. So for most low income obligors, they never even have a chance. They start multiple $1,000s in arrearages, right? And their license suspension is automatically suspended from the get-go, right? So they never have a chance. So this legislation just makes tons of sense for everybody involved. It's good for custodial parents, it's good for children, and it's good for non-custodial parents, and I support the effort.
Thank you very much, Mr. Hatcher. There are questions for the panel. Let's start with Delegate Arakan, then we're going to Delegate Watson. Then I might have a couple. Delegate Arakan.
Thank you, Mr. Chair. Thank you so much, Delegate Davis, for this great bill. Can you remind me again what the bill number was last year and what happened?
I don't think we did anything.
I didn't have this bill last year.
You didn't? Somebody had this bill, I think, or a bill like.
Someone had some, I think Delegate Moon might have had something similar.
There was
Okay.
something similar, but it wasn't this.
Okay, all right. Well, that, okay.
Sorry, you weren't asking me, but there was something similar, but it wasn't this.
Okay, thank you.
All right. Delegate Ron Watson, please.
Thank you, Mr. Chairman. Question, I think probably for Mr. Deuce. So I like the bill. I don't think it serves anybody, whether you're low income or not, to have your motor vehicles license impacted if you're in arrearages. If you can't get to work, it's going to impact you. I don't care how much you make. So my question is, why is the amendment to this so important? And how does it comply with some federal statutes with this 300% poverty line provision? Why can't it be applicable to anybody?
Yeah, so in a nutshell, the way I believe it's 42 US Code 666, and which is fitting, 66, never mind, I shouldn't make that joke, it's professional here. So the point is that the way the statute is listed out, it says that you have to have some form of a suspension program. Professor Hatcher can talk more about this. And so honestly, as an employment, a workforce person myself, I would love to see the idea of suspending driver's licenses for non-payment of most bills totally revoked. I mean, I don't see any correlation between or any benefit between having licenses suspended and to pay a debt. It doesn't seem to work. And if you think about, I think it was House Bill 280, Senate Bill 234 that passed through the committee last year. It discusses this exact issue of suspending licenses for non-payment of fines and fees, right? That we actually ended up repealing or restricting suspensions for those reasons as well. So, I mean, it has precedent. The only reason why this issue hasn't, at least in my experience, hasn't really come strong is simply because of the federal funding requirement that says that you have to have a suspension mechanism, but it doesn't necessarily specify how that's supposed to look. And that's why the advocates and myself push for the 300% federal poverty line. But I would love for that to go higher and for a push to happen to allow for all workers to resist license suspensions, specifically if it's going to interfere with them being able to obtain employment and support their children.
So just make sure I'm clear. So if we got rid of the 300% poverty level and made it something less, that would start to impact some federal statute. Is that fair to say?
No, I apologize if I was not very clear about that, Delegate. No, if you repeal the statute altogether without our 300% amendment, then you might run into some issues with federal funding. However, because of the 300% amendment, and it can go higher, it could be 400, it could be 500. The advocates, we just wanted to start with 300, but as long as you have that amendment in there, you're not going to risk any issues with federal funding.
All right, and real quickly, Mr. Chair, for Mr. Hatcher, you mentioned some metrics associated with low-income obligors, right? What about the non-low-income folks? I mean, what kind of metrics do you have as their ability to pay once their motor vehicle licenses are taken away, their privileges?
Well, it's a great question, Delegate Watson, and I think part of the challenge too is who is low income, right? There are several populations who are struggling who are well above the poverty level, well above 300% of the poverty level, and I've never seen any evidence to show that the license suspension program actually leads to any significant payments, right? The efforts I have seen, whether it's in Maryland and in other states that try to link the child support suspension program to payments of child support, they provide numbers that are also linked to cases where there are these other more effective enforcement tools happening, right? Like wage garnishments or tax intercepts, right? That do have some success in leading when people are working, their wages are garnished. Now, I think the wages are garnished at too high a percentage, but that's a different bill, right? But I've just never seen any evidence that the suspension program is actually successful. It causes a lot more harm than good across the country.
Thank you very much. And I believe this is a bill that's had its day and needs to be fully repealed. To me, it's just another form of debtor's prison, just framed differently. And I don't think it serves anybody any good, especially our children. So thank you very much.
Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, committee, and people came in to testify. So, Mr. Dews, what is 300% poverty level for a single person? And I just wanted to make a comment in reference to your 666 comment. That's not a draconian number, but a number for the ego in the Greek, which is heparin.
First of all, Delegate Conaway, I want to thank you for the question, and I want to thank you for the clarification on that number. That's information that is new to me, and I thank you for that information. So with regards to the question, the actual 300% federal poverty line for a single individual will be $38,640, which is, I used to have this number on the top of my head hourly, but basically $38,000.
Thank you so very much.
Thank you.
So I have a couple questions. So you kept the overall process because if you got rid of the process, then that would run us afoul of the federal guidelines. So I got that. My first question is, who determines what the person's income would be? And I'm going to take a couple steps backward. The current process, as I understand it, and to Delegate Deborah Davis's point, the challenge here in part is that it is automated. That if there is no payment, the driver's license, it immediately goes to MVA and bang, your license is suspended. And until you fix that problem, it remains suspended. I guess the question is not necessarily as a defense to having an automated system, but now if you add this requirement in that says now we have to determine whether they are are they living alone and do they make less than $36,000 a month, or how many people are in the household, and then determine that, who precisely will do that? Yeah, Mr. Hatcher.
I can try to give it an answer to that. Thank you for the question. I think it's a very good question. And automation is, in theory, can be helpful, but it can do a lot of harm. But a much broader discussion on this particular issue shouldn't be difficult because the information is already gathered through the process of beginning a child support obligations through the guidelines. They determine what the relative income is of the non-custodial parent and of the custodial parent. So the numbers are already there. Right, just simply plugging that into the automated system. The child support notices, the part of triggering the license suspension, is already automated, right? So these numbers, by adding in this is simply a trigger that they wouldn't kick into the automated process of sending out the notice of suspension, wouldn't happen for those individuals who are at 300% of poverty or below.
So you would be relying, though, on the initial number when a person first entered the child support order. So it's year one, and they enter in the amount of money that they're making on year one, and it might be $30,000 a year, and they might be living alone. But now it's 2 years later, and they're not living alone, or it's 5 years later, and maybe they have kids from a new relationship, and now the number is different. But are you still going to be going off the number? I really am not trying to be obtuse here. But I think this is a problem because people don't make the same amount of money from day one to day 361 and down the line. People
Right.
becomes change over time. They go up and they go down. And Delegate Davis wants to talk. Let me stop.
Can I take a stab at it, please? I believe in other areas of the law, we offer the exception. So when you get the notice, when the client, the debtor gets the notice, they can apply for the exception. and they could say, or there could be a hearing process. I don't know. There could be some way to say that your income has not changed. We do that now with modifications in child support. I mean, there are processes now. I don't think it's real difficult. I think we're getting into the weeds of a system that we don't really know about, and we're not going to figure out the answer. I mean, it would be up to child support to figure.
Well, but
That's right. If I could add too, the custodial parents and the non-custodial parents and the agency are all obligated to keep updating the information, right? So if income changes, both parents are supposed to be updating the agency, and the agency is supposed to be conducting periodically their own investigations, right, to look for a change in income. So it's not perfect. It might be a little bit behind, a lot of times because of the agency not acting as quickly as they should. But it will, if they're doing their job correct, it will become accurate, if that makes sense.
But when the license is suspended, MVA will do the license suspension. So I guess the other question will be from me, well then who handles that appeal of the license suspension? Is it MVA? Is it child support?
Office of Administrative Hearings.
Yeah, if I can jump in. So the process is, thank you. I'm sorry to jump in. Stacey Bensky, I'm from Maryland Legal Aid. So the process is that once the obligor gets the notice that their license is going to be suspended, they can, of course, they can request an investigation with the agency. Again, the issue with the automated system, though, more I'd say than what you're kind of bringing up, is that a lot of, at least for low-income clients, they don't get the notices in the first place because, for example, like my clients at Legal Aid, most of them, a lot of them, good number of them don't have stable homes and stable mailing addresses. So if they never get the notice, then they can't ever ask for the investigation. And then, but the next step from the investigation, if the agency says, no, we're still suspending it, which I'll be honest, it's not really an investigation. It's just someone says to them, no, we're still suspending your license, then they can appeal it to OAH. If OAH decides against them, they can appeal it to circuit court. But it's very rare that those happen because most of the people that are dealing with the child support agency are unrepresented. But like I said, the bigger issue is,
I guess, and then that brings me to my next question. But then one of the critical problems that we have with access to justice, and with this could sound snide, and I don't mean it directed at Legal Aid because you deal with access to justice all the time. That is, we're going to be dealing with people who are 300% of poverty, who generally speaking have a harder time accessing these, appeals and things like that, probably don't have time to go and deal with appeals.
Right.
And so I'm not saying that it's not an elegant solution. I guess my question, my bigger question is, again, it seems like it's setting up another hurdle for people who are impoverished. It seems like it's setting up another hurdle for them to deal with. And that to me kind of, that hits me in a weird place in some ways. My experience is, when you start as a prosecutor, you deal with these driving suspended cases all the time. And usually what happens is, did you pay? You're done. And whether it's because you failed to pay a fine or something like that. And that doesn't happen everywhere. And it's not every prosecutor. And maybe I'm perfect and whatever, fine. But no, I'm not. And I can see my committee's face. So fine. But the question, I have seen cases where people have paid their child support, or more likely than not, the payroll company simply made a mistake and didn't pay the money, and it throws them for a loop because they don't realize that they're suspended.
Right, absolutely. So that's why, to your point, it's not creating a new problem. The problem already exists. Like my clients who are below the poverty level are constantly getting license suspension notices, and not just once, not just twice. Over and over every month, because they're never, especially if they're on disability, they're never going to get, like, let's say their arrears accrued while they're waiting for disability benefits and unable to work, right? So they're always going to be in that level in that pool of people who could be picked in that automatic random lottery, because unless they get below 2 months worth of arrears, they're never going to. So I have clients who, I've had the same clients for 2 years, because every 3 months they're saying, oh, my license is suspended again. It happens all the time. So what this would try to do would say, well, if you're below this, it would stop that suspension from happening in the first place, is what this bill is trying to do. My concern is that the automated system that the child support agency uses will not follow this, because they already don't comply with there already is an exception in here in 10-119. It's 5 I think, oh no, I'm sorry, C5I, that says that if you're paying on your arrears each month, that you cannot, through an agreement or a court order, that you cannot be referred to the MDA for license suspension. But my clients, like the client example I gave, I have tons of clients like that who they're seniors, so their disability, either their disability or sometimes it's joint disability and retirement. So it's only arrears, right? So they're paying on their arrears through earnings withholding orders on their Social Security every single month, but yet every couple months they get a license suspension notice. So what I'm saying is that the bill that respectfully, that Delegate Davis and that Chris Dews and everyone else has worked so hard on, and that I support it, but I think that the issue, just so I'm making sure I'm clearing up, I think the issue you have is sort of different than what the issue might actually be, if that makes sense.
I just wanted to say, Chairman, very quickly, Priya, who's also signed up to testify from the Fines and Fees Justice Center.
The next one? Okay.
The next panel, so I just wanted to
That's fine. I'll suspend because Delegate Williams has been waiting very patiently and I've talked too long. Yell at other people for talking too long. Delegate Williams.
Hi, Mr. Chairman. Thank you so much. I just had a quick question. With COVID going on, one of the things I know I'm seeing in my practice, and I'm sure a lot of other folks are also seeing, is just really kind of the backlog of just cases in general that are going on with the courts, suspending, hearing certain cases and things like that. And I guess my question is, how has that kind of affected all of this? As it relates to child support suspensions, and things like that. I just was kind of wondering, I don't practice family law directly every day, so I didn't know if that's been super, also affecting that area as well.
I can speak to some client examples, at least for clients, particularly in Baltimore City. The child support agency has not been, if anything, not lenient at all, if anything, tougher. I mean, I've had clients who have had, most of the jobs, there's so many like delivery jobs that became available around COVID. And I have clients who had job offers, but they said, but the job offer was contingent on having a valid license. And the child support agency, had said, unless they already have a job, we're not going to lift the suspension. And we had to I had to file emergency motions and they were granted, but by that time, there went the job opportunity. So,
hold on, I just want to make sure I'm understanding this correctly. So COVID, people are getting laid off from their job. They child support, but they're not there, and their licenses are getting suspended because laid off from COVID. And the child support people are continuing to keep the licenses suspended and preventing them from getting a job so they can pay the back child support.
Yep, absolutely. I had one client where he had about 4 different job offers. It was either trucking or delivery, that's what all of them, and all he's ever done is driven. So he's either now he was doing like Uber on the side as he was trying whatever, but even that, then he lost his job with Uber because of his license suspension. In any case, and they just said, no, unless he has a job already, then we'll lift the license suspension. So then the resources that had to go into it for Maryland Legal Aid, to do an emergency motion for the court, for the agency, all these state resources, because they're so tough on this, and because of this automatic system that it doesn't allow to treat people like individuals. And this particular client, his children were actually with him. They were with his mom, but because of COVID, mom fell on hard times. And so the kids were actually with him. So on top of everything else. So the system does not treat people like individuals. It's not a case by case. Yes, the license suspension will work. To answer a question that was asked earlier about, just to real quick go back, they asked about when license suspensions work. The only time I've ever seen it in family law practice work is super, super, super wealthy people. And that is it. Never, low income, and never even really middle, medium incomes, very, very wealthy, which again would be if the system was able to work on a case by case basis, then that's the, the situation where maybe it should be used and could work.
Okay. All right. Thank you for answering that.
So thank you.
All right. I'm sure there'll be more questions, and I guess what I'll throw out is kind of riff off of what Ms. Bensky is saying. I guess is I'm kind of wanting to maybe explore in the next panel, because I understand that help is on the way, maybe, or with no offense to everybody who's talked here, but I guess one of the questions going back to that automated system is, from my experience, it is arbitrary and it is fast. And on the one hand, that is good, but on the other hand, it doesn't allow for the situation that Delegate Williams was lining out, where you have somebody who loses their income and everything because of COVID, but maybe in the computer it shows that they were making $90,000 a year, so they bang, or it ties them up in more red tape if now they have to go and prove that they have less than 300% of poverty. Having said that, I've talked too much, so we'll next panel and go from there. And we will hear next. Thank you all very much. We'll hear next from Priya Jones, Jason Rodriguez, Rudolph Hansen, Nicole Hansen-Mundell will also be there. And unless she's having a party with Delegate Crutchfield about some bill we worked on earlier today. But having said that, those four will be next. We'll go with Priya Jones, and whose reputation apparently has preceded her in this bill hearing. So we'll go with you for 2 minutes, please.
All right, I hope I don't let you down.
All right, a lot of pressure here. It's a lot of pressure.
So thank you for having me testify today in support of Maryland's House Bill 0580. My name is Priya Sarthi Jones, and I'm the National Policy and Campaigns Director at the Fines and Fees Justice Center. A debt-based driver's license suspension is often thought of by the government as an effective tool to get payment for unpaid public debts. However, even though this practice has been in place for decades, there is no evidence that supports that it is being an effective method to ensure payment. We know this to be true in the space of fines and fees, where driver's license suspensions are counterproductive and extremely harmful to low-income communities and communities of color. Black residents in Maryland are 5 times more likely to experience license suspension than their white counterparts. In areas with poverty rates lower than the state average, the average of 9.3 of Black residents receive license suspensions, a rate 3 times higher than their white residents in similar areas. These statistics are reflective of what we know about debt-based driver's license suspension across the country. The policies harm Black, brown, and low-income communities at disproportionate rates. And where this practice has ended, we see neutral to positive impacts on debt collection. Maryland itself took steps in this direction just last year when it ended driver's license suspension for unpaid traffic fines and fees. The fact is that debt is debt, regardless of the source, and the same principles, evidence, and values that led Maryland to end one form of debt-based driver's license suspension last year applies to addressing it in the use of unpaid child support. It doesn't work, it causes harm, it creates significant barriers to employment, it's ineffective, it leads to entanglement with the criminal justice system. And while there are federal statutes in place that influence whether a state can entirely eliminate this practice, it is very clear that the requirements are, and others have covered these today, it doesn't need to be automatic or mandatory. And the study shows that the most effective way to collect unpaid child support is through wage garnishment. It requires the least amount of resources from the government and the most impact on actual collections, neither of which is true for driver's license suspension. With the proposed amendments to this bill, we take a step towards ending automatic driver's licenses for unpaid child support wholesale. It would be easier for all of us if the narrative for those who don't pay fines, fees, and child support or why they are late on their payments are always done so willfully. It allows us all to shift the blame and accountability to those individuals and not our policies. However, the truth is that is not a willful disregard for one obligations that lead most people to having their license suspended. It's circumstances, it's hardship, it's economic barriers, it's and underemployment that create those circumstances. And it will be policies that address those issues that result in different outcomes in the space of economic justice and the criminalization of poverty. I thank you for the opportunity to address this bill, and I'm happy to answer any questions today.
Thank you very much. We have Jason Rodriguez next. We're going to let him talk there. No sign of Rudolph Hansen or of Nicole Hansen, and that's fine. If we see them show up, we'll pull them onto the Zoom. But for now, let's hear from Jason Rodriguez for 2 minutes, please.
Good afternoon, Chairman, Vice Chair, and to the committee members. Can you hear me?
Yes,
Okay.
go ahead.
Good afternoon. So I'm here today in support of this bill as a community activist in Baltimore City, as well as a former child support payer. My child now is in the 20s. I was actually on a payroll garnishment at the time. And even though I was under a payroll garnishment, I could tell you many experiences that I've had with my license being suspended, many times not even knowing about it, being pulled over by law enforcement after they, got behind me and ran my tags and found out that the driver that may be associated to this tag has suspended license. I had to pay numerous fines. At the time, the company that operated child support was a company called PSI. I had to go down to Charles Street on many visits. And when I would get down there would be numerous other gentlemen that would be in there as well that had to take time off from work, go down to PSI to be able to get the flag lifted. And then many times you get the flag lifted from there, you still have to go down to DMV and make sure that it's cleared up on, I believe it was like the 4th floor in DMV. I used to work at Comcast at the time, and Comcast regularly would do spot checks to make sure that drivers were valid. I could tell you numerous times driving for my company where I was shut down and was unable to work for that week while I tried to get it straightened out because they had took me off the road because my license was suspended. Now, again, my license should not have been suspended. But what would happen normally would be is that the way payroll would process my garnishments, and especially if it was a holiday, by the time PSI would get documentation to document that the child support was paid on time, and I had no arrearances, by the way, so I was paying up to date. By the time they would get the record of the child support being garnished and actually paid, many times there was a delay in the system and they were quick to pull the trigger and to suspend my license. So that's why I'm here today to testify. I've seen numerous young men in our community be directly affected by this policy, as well as myself, who numerous times have had loss of wages, loss of hours, and just loss of time trying to get this situation straightened out. So I ask that the committee votes favorably for this bill.
Thank you, Mr. Rodriguez. Thank you very much. We have a question from Delegate Carden, please. Delegate Carden?
Thank you. I'm using my iPad, so I'm a little unsure. Thank you very much, Mr. Chairman. To the young lady who testified, I just wanted to clarify, Ms. Jones. There's no requirement for us to use this automated system in order to get federal funds. Is that true?
Yeah, that is true. So the way that the federal statutes work on driver's license suspension for unpaid child support, part of a larger child support enforcement package, right? So there's a lot of other factors that have nothing to do with driver's license suspension that are part of this child support enforcement program and act. One of them is that every state, in order to receive the funding that comes along with that child support enforcement, has to have laws on the books that allow you to suspend driver's licenses for unpaid child support where that is appropriate and where it will be increase the effectiveness in the program. So I think to the young woman. Oh, go ahead.
No, I'm just wondering. So if we got rid of the automated system, we're not in jeopardy of losing federal funds. So wouldn't that help solve this problem?
Yeah, I think that if you wanted to just wholesale say that driver's license suspensions are not automatic for unpaid child support, that they will be handled on a case-by-case basis where if the court finds someone's acting willfully withholding child support payments from their children, from their families, and that they believe that suspending the driver's license in that case makes sense, as the woman before indicated, that may make sense where a wealthy person who wants to, stick it to their family or whatever the case may be. But it allows the court then to have the discretion to really assess the circumstances and use that tool where and when appropriate. I think that the goals of these amendments sort of try to capture a larger group of individuals who are finding themselves automatically suspended for their circumstances. And so it's an attempt to really do that, but you could deal with it another way by just not making it automatic and letting
I'm reflecting off of what the chairman was asking with questions regarding, the ease with which we can make this system easier for people to actually take advantage of this amended system. And if we can't come up with a system, why wouldn't we just get rid of the automated system and then let, for the small number of people that this actually could actually have influence over, just focus on figuring out a new policy to deal with those people?
You absolutely could. So I think the original bill, as I read it, was that this was to repeal driver's license suspension wholesale for unpaid child support, and that advocates and folks worked together because of this federal legislation to try to come up with a solution they thought would allow for the most amount of impact. There are other solutions too, which could be that you don't do them automatically at all, and then you allow the courts to decide on an individual basis. There are risks in all of that without parameters of how a court may make those decisions of when child support, it's appropriate, right, to suspend someone's license for unpaid child support. And there are some income-based factors that may create presumptions, such as 300% of the poverty level. But, those are all things that you can work out in court process, or you could say that there are presumptions that would never allow a court to suspend a driver's license for unpaid child support, such as 300% of the poverty level. That could just be an automatic way to not include someone and even any optionality for having their driver's license suspension, but it doesn't have to be an exclusively written sort of amendment.
Thank you. Thank you, Mr. Chair.
Are there further questions for this panel? Just to be clear, there are 14,800 people, 14,800 people whose licenses were suspended last year for child support. So if we didn't have an automated system, somebody's going to have to go through and look at all of those. And I guess the question would then be, who does that and how much that would cost? So Ms. Jones, if you'd like to speak to that a little bit.
Yeah, I will also just say that not many states don't have it as an automatic thing. So just so that would not, this wouldn't be inconsistent with how other states may run their child support enforcement driver's license piece, whether it's mandatory or discretionary. As far as going back and looking at the 14,000 plus number that you indicated, I mean, there is the sort of quick and easy answer, which is folks can reinstate all of those driver's licenses, so similar to what we've done with unpaid fines and fees. And then moving forward on a case-by-case basis, you can determine whether any of those 14,000 plus do require you to suspend them again based on findings, right? That they are withholding child support, they're willfully withholding it. My guess is going to be that the vast majority of the 14,000 plus would not fall into a category where they'll find themselves suspended again.
Who is you?
So this is going to depend on your system in Maryland, but if the DMV or I think it's called something different in Maryland, but effectively your DMV in Maryland can just reinstate those licenses automatically through their system. Some systems allow them to do that, right? Just flag that we are changing the law and all of these licenses are now reinstated. And there's almost for lack of a better term, a flip of a switch and all of those licenses get reinstated. Right. If that can work in Maryland, that would probably be the most effective and efficient way to do it. It's possible they have to be identified and then done on a case-by-case basis, but that also is just based on your systems in particular.
Delegate Deborah Davis.
Thank you, Mr. Chair. My question is for Mr. Rodriguez. My first question is, isn't wage withholding automatically done in child support? And isn't, in your case, you had an automatic wage withholding and were still being suspended?
Right, it happens.
Yes, Delegate. So in my particular case, it was the timing in the reporting from our payroll, from HR, to the actual company that was handling the actual garnishments. So by the time they would get the information from my payroll department, there was a certain amount of days that they would have to automatically start to flag you if you didn't reach that certain amount of days. I believe it was 14 days they gave at the particular time. I'm not sure if it's been changed or adjusted by now, but if I went over 14 days, they automatically sent the flag to MVA, which immediately suspended my license. And then the proof of Burton fell on me to get it straightened out. Even after they received it from payroll, it seemed like the company never went back and said, oh, we've now received it, let's go into the system and unflag the license. And that would never happen. I would always have to get in contact with the management agency that was handling the child support garnishments and fight with them to get them to send a notification to MVA to have it lifted.
All right. I have talked enough, and then everyone else has asked their questions. So we thank you all very much. That concludes, right? Yes, that concludes the testimony for House Bill 580. Thank you very much to Delegate Davis and to everyone who testified today. We thank you very, very much. Now to Delegate McComas. This is House Bill 701. 701, and there's only one witness, and it's Delegate McComas, and she's going to go for 3 minutes.
Okay. All right, here we go. This is testimony in support of HB 701. This bill has been seen several times by the Judiciary Committee. In 2020, HB 820 had a hearing, but because of COVID, there was no vote, and I had to choose between one bill and another, so I had to take the other bill. In 2019, HB 1252, same bill passed. Passed the House and received a hearing in JPR, but nothing further. And then HB 600 in 2018 passed the House with only passed the House, but went to JPR and heard crickets, nothing, zippo. Okay, now there's been some, my written testimony, there's been some mistakes. So if you look at the prior introductions, that's the most correct information. This is really important bill because given all the stressors with the pandemic and children being inside and not being in school and parents being stressed, it's likely that there's predictions that we're going to have an increase in child abuse and neglect. So it's important that folks know what to look for. And this bill has, I think sometimes the simple can become complex. I know that it's supported by a number of the advocates in the communities of child abuse and neglect. And I'll just say that the Coalition to Protect Maryland's Children, the following members signed on to that testimony: Advocates for Children and Youth, Associated Catholic Charities, Board of Child Care, Child Justice Inc., Citizens Review Board for Children, Court-appointed special advocates, the Family Tree, the Maryland chapter of American Academy of Pediatrics, the Maryland chapter of the National Association of Social Workers, and the State Council on Child Abuse and Neglect. Plus, you have individual letters from the Center of Hope, which used to be the Baltimore City Child Abuse Center, but has now aligned itself with LifeBridge group, but they still do that work, and they have a letter of support as. And I am kind of concerned that the Board of Physicians had an information, and it's kind of like, well, we don't know what to do. Well, they don't have to do anything really. It's just a matter of providing access to good quality material when licenses are renewed. We have the Psychological Association, which they support the bill, as well as MCASA, which supports it. So anybody that has dealt with someone that has a history of abuse or neglect, that follows them into adulthood. And there's the ACEs program, Adverse Child Events in their life, and that it follows around for life, and you can have physical problems and emotional problems. So I think it's really important that people are able to identify suspected child abuse and child neglect and abuse. And because these are going to be videos that are going to be online free, it's a good way for all of us to become more aware. So with that, because this is a good bill, I would ask your support.
All right.
John, Delegate Cardin's smiling. I don't know if that's good or bad.
Well, you said that we should support the bill because it's a good bill, and I'm sure that just checks the box. It's done, right? All right, so.
Not in this committee.
All right. Are there questions for Delegate McComas? Hearing none. Thank you very much, Delegate McComas, for your legislation. That concludes
And if you need any other information, let me know. And thank you.
House Bill 701. That concludes the testimony for House Bill 701. Let's go now to House Bill 270. And this is, there she is, Delegate Karen Lewis Young. And she'll be joined, although she's favorable with amendments, but we'll bring her in anyway. And because there are only two witnesses, Lisa Jordan, let's hear from her too. So Delegate Karen Lewis Young, you're going to have 3 minutes to talk about House Bill 270, and then Lisa Jordan for 2. So go right ahead, Delegate.
Thank you very much. Nice to be before you again. I have a bill that I believe will bring some closure to victims of sexually assaulted behavior. It's a rather straightforward bill. What the bill does is it requires an assistant state's attorney to meet with victims of sexually assaultive behavior at either the request of the victim after a decision not to file, or a charging document, or against an alleged suspect, or to discuss charges against an alleged suspect. Let me tell you how this bill came to pass. I had a call from a constituent who was extremely distraught from depression and anxiety. She had been sexually assaulted. The perpetrator was not prosecuted, and she had no idea why. So I reached out to my local law enforcement agency and I said, give me some guidance. What can I do? Is there any recourse? And so I want to read you a very small portion of what I was told by the acting chief of police. This, unfortunately, is not atypical. I know there are numerous bills presented concerning the rights of sexual assault victims, but perhaps you could add some kind of inclusion of requiring the victim services advocate of the state's attorney office to meet with the victim of sexual assault to explain the reasoning behind the decision not to prosecute. After the bill was drafted, I checked back again with leadership of my local police department, who said, I believe this bill will actually prevent potential conflicts between law enforcement agencies and the state's attorney office. Trying to talk quickly and I'm stumbling, sorry. I could give you all kinds of statistics about the very low percentage rates of sexual assault crimes that are actually prosecuted. I suspect with your expertise, you know that already. Also, there is a very high percentage of post-traumatic stress syndrome from individuals that have been sexually assaulted. All the trauma, as well as maybe not knowing why. There was never any closure for them. I want to thank both Lisa Jordan and Ms. King from the Frederick County State's Attorney Office for working in a very collaborative manner to bring an amendment forward that actually achieves a compromise and works both for the victims as well as the prosecutor's office. And as I said in my introduction, I do think that it will bring some small semblance of closure to those who feel that they have been denied the opportunity to bring their case further.
Thank you very much, Delegate. Thank you very much. We'll go now to Lisa Jordan for 2 minutes, please.
Thank you, Mr. Chairman, Madam Vice Chair, members of the Judiciary Committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 270. Thank you also to Delegate Young for continuing to advocate for the rights of sexual assault survivors. Delegate Young is correct. Of every about 1,000 sexual assaults, 9 get to the prosecutor. Just 9. So we're asking that those people who actually get to the prosecutor's offices have the basic human decency and respect to have someone tell them why their case is not going forward if it's not going forward. And I have to say, you know, at the Sexual Assault Legal Institute, we help over 400 sexual assault survivors every year. And every single one of them gets, you know, kind of a free legal checkup, everything that's going on. We talk about criminal issues, and a shocking number of them report to the police and then they hear nothing ever. And so this is one of those bills that just feels like such common sense. It feels somehow wrong to have to bring it to the General Assembly, but we do have to bring it to you so that we actually treat sexual assault survivors who come forward and report their assault, and it gets to the state's attorney's office, and then for sometimes very good reasons can't go forward. They just need to have the courtesy of an explanation and a response. So for those reasons, we urge a favorable report on House Bill 270.
Okay, that's the testimony on the bill. Are there questions? Yes, there are. Delegate Grammer to begin. Unmuted. Delegate Grammer. Hi, Delegate Grammer. No, we can't hear you.
She asked to come back to him.
All right, then we will. We'll go to Delegate McComas instead, and then we'll come back.
Thank you, Mr. Chair. I just wanted to ask Ms. Jordan, since she can tell us how many years she's been working in this area, but I would think that that the explanation of why it wasn't prosecuted would be a tremendous help to the emotional and psychological problems that the victims might have because the case wasn't prosecuted, because, you know, they would understand the system. They would understand that, you know, the prosecutor's not going to take the case unless it's really, they can prove it beyond a reasonable doubt. And so I just kind of wanted your comment on that. If you think that this would go a long way to creating some peace in their souls.
Thank you, Delegate McComas. That's an excellent point. It's absolutely correct that it does help people understand when something isn't going forward. It also, in some cases, I will tell you, the victim will talk to the state's attorney. The state's attorney will say, well, because we didn't know about this. And the survivor will say, well, but wait, I can give you that evidence. I can give you that piece of information. So it works both ways. But you're right. Primarily, this is something that's about respect. It's about courtesy, which is required by our Constitution in Maryland. So we should do this for crime victims.
All right, we're going to go back to Delegate Grammer again and see if it works this time.
Thank you, Mr. Chair. Can you hear me?
Yes, go ahead.
Fantastic. I have 2 brief questions. Good to see you, Delegate Young. Good to see you, Ms. Jordan. I've dealt with cases where a constituent has escalated something to the prosecutor's office, and sometimes it doesn't get pressed. My first question for Ms. Jordan, is there any system anywhere, whether it's in this state or another state, where they have a structure of responding in some way when a situation is not escalated? I guess providing a justification for why charges were not prosecuted, be it for a sex crime or otherwise. Is that exist anywhere in your experience?
Delegate Grammer, I'm not aware of any other state that has had to legislate this issue, but yes, it is a a common practice. It's a human courtesy. It's a professional obligation, I would even say, as a lawyer, to say, particularly to a victim of a potential felony, why you're not going forward.
But is it standardized like on paper? Is there a structured system other than just getting back to the folks?
Not that I'm aware of, sir.
Okay, second question. Let's say you're escalating a situation to me. You're a resident of Maryland. I'm a prosecutor. I get a sex crimes case. I start investigating. I find a circumstance which I believe there is justification to the case. I'm deploying my resources. I think I have something. And then, you come to my office, you're calling me. I would be inclined, I think my response would be, if I did suspect wrongdoing, but I didn't have enough to move forward, I suspect my response would be, I can't speak about a pending investigation. That's what I suspect the prosecutor's office would say in a valid concern.
Absolutely.
What happens in this scenario in that case?
Well, Delegate, thank you for that question. This bill would not be triggered yet, because if you look on page 2 of the bill, there are only 2 circumstances where there'd be a required meeting. One would be they're not filing the charging document against the alleged suspect, and the other would be the decision to dismiss. So the scenario you're talking about, when it's still under investigation, that you haven't reached that point yet. And often at that point, when the prosecutor is not interacting with the survivor, the victim witness attorneys will do that. The crime victims' rights attorney may do that. I think it also might be relevant to your understanding of this, that we do have a law in Maryland regarding rape kits. So if you've actually had a physical kit, you have a right to get information about that kit. So this is very much a similar concept.
But wouldn't the investigation happen before the filing of charging documentation?
Yes, but not before the decision not to file a charging document. And if you read the language of the bill, that's when this would be triggered. It would be the decision to not file the charging document. So the investigation would have to be complete.
Okay, well, I appreciate it. Thank you.
Delegate Conaway. Oh, no, wait. Delegate Bartlett, then Delegate Conaway. I'm sorry, Delegate Bartlett.
Thank you, Mr. Chair. You're not seeing things. I put my hand back down, then I put it back up. Because of the last thing that Lisa Jordan said, and I wanted to make sure I understood, with respect to the Anne Arundel County former corporal who threw away or threw in the trash some of the rape cases without, this bill may or may not have been in play because it would have been still under the quote unquote investigation phase. And there weren't any charging documents, but it was just like a pending, it still wouldn't have triggered this bill. Is that correct? Or would it have triggered this bill or this situation?
Thank you, Delegate Bartlett. I'm not sure that I fully know all of the factual underpinnings of that really tragic and horrible situation. Certainly for those cases, my understanding is that there were some actual kits that were thrown out, and the survivor would have a right to know the status of those kits. I think at this point, what this bill would do is that apparently the state's attorney's office is not able to go forward on those cases. They would not be permitted to simply remain silent and ignore those survivors. They would have to explain to the survivors what happened, including that the evidence had been destroyed.
Thank you.
Now, Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Ms. Jordan, for coming and testify. So on the rape kits that you're talking about, would the victim have to request the information as to what the status of their kit was, or if is there any change in the rape kit? Let's say if it's destroyed or tampered with, are they supposed to be notified? How does that work?
So the bill that's before the committee, House Bill 270, is not specific to kits. It's specific to any situation. So it's somewhat different. You've already enacted a law that requires that if a survivor says, I had a kit, What's the status? You have to respond to that. I do suspect, though, within the next, say, 5 years or so, maybe even less, we'll be changing that, because this committee has instructed that the Attorney General and his Sexual Assault Evidence Kit Committee institute a tracking system, and that will allow survivors to track their kit through the whole process. And at that point, that statute may need some amending.
All right, and you gave a figure 9 of how many people? You said nine people are charged out of how many complaints?
For every 1,000 sexual assaults that occur, about 9 of those cases go to the prosecutor. Now, that includes unreported cases as well, and of course is an estimate.
All right, thank you very much.
All right, are there further questions for the panel? Seeing none. Thank you all very much. Thank you, Delegate Young, for being with us this evening. Thank you.
Thank you.
All right, Delegate Dumais is here. We're going to House Bill 744. And there are 3 people to testify. Delegate Dumais plus 2, Lori Ruth and Dawn Lindsay. There's 1 person to testify, an opposition delegate, but he has emailed the committee and indicated that he will not be joining us this evening. That is Vince McAvoy. So Delegate Dumais, you're going to get 3 minutes, and then everybody else will get 2, and we will let you begin.
Thank you, Mr. Chair and Madam Vice Chair, and good evening to the committee members. This bill is really just clarifying an administrative cleanup. For the most part, when you file cases, every county except Montgomery, for whatever reason, can charge what's called an appearance fee for an attorney that is entering an appearance. And it's not supposed to happen for domestic violence cases. And generally speaking, it's never happened to me when I have filed a domestic violence case, but there were a few reports of a couple of counties where the whether it was the attorney for the respondent or the attorney for the petitioner was charged the $10 fee, appearance fee. This bill simply says a fee may not be collected under this section for docketing the appearance of petitioner's counsel in a case filed under Title IV, Subtitle 5 of the Family Law Article, which is the domestic violence statute. I have an amendment that I have sent to the committee, because once I actually saw the bill drafted, it should say petitioner or respondent. And so I do have an amendment that will indicate that the respondent's attorney also should not be charged the appearance fee. That truly is the bill. And with us today, I think on behalf of the Judicial Conference, Dawn Lindsay is actually the clerk of the court for Allegheny County. And I think you all know Lori Ruth from the Women's Law Center. And that's the sum total of my testimony.
All right, and it was under 3 minutes. So we'll go for 2 minutes and see if they can do even better. We'll go to Dawn Lindsay first from the Judiciary, then Lori Ruth.
Hi, I'll do even better. I'm Dawn Lindsay, the Clerk of Circuit Court in Allegheny County. The Maryland Judiciary supports House Bill 744. This bill prohibits the clerk of a circuit court from collecting fees for docketing the appearance of a petitioner's counsel in certain domestic violence cases. This bill will clarify the ambiguity on whether circuit court clerks are to collect the appearance fees from petitioner's counsel in certain domestic violence cases. In addition, pursuant to Stop Violence Against Women Act, federal grant eligibility conditions, states are required to certify that there is no fee or cost involved when a protective order is requested. This applies to both the petitioner and petitioner's counsel. House Bill 744 will codify the federal law which prohibits any Maryland court from charging a fee to a person seeking a protective order or a person who acts as counsel for a person seeking a protective order. To do otherwise is to fall out of compliance with the Stop Violence Against Women Act, with significant consequences regarding federal funding. That's all.
All right, that's great. Let's go with Lori Ruth, please, for 2 minutes.
Good evening, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. obviously, I think you can tell this is a very simple bill. In fact, when we saw it, I emailed Delegate Dumais and said, why in heaven's name do you need this bill? And she said, it's because of you, Lori. You took this to the judiciary because your attorney was forced to file an appearance fee. So I went back and checked, and indeed it was me. And I really appreciate the judiciary being responsive to this. There are two conflicting statutes. We need to comply with the VAWA. And this would clarify that. I did ask around some colleagues and whatnot. It happens not that often, but in a handful of cases and in different jurisdictions. I suspect it's, turnover in the clerk's office causes some confusion, and they just don't know which statute they're supposed to be looking at when they send out the appearance fee request. So we would love to clarify the law, make it clear. We'd love to comply with VAWA. And for those reasons, we urge a favorable report. Thank you.
All right, this bill apparently was Lori Ruth's fault. So, all right, are there questions for the panel? Delegate Williams.
Just really quickly, is there any reason why anybody anywhere would have any opposition to this bill? It seems pretty simple.
I don't think so. The only opposition I could think is the fact the way the bill's obviously up on the website, it applies only to petitioners. It's my amendment that will make it clear that it's also for respondents. And so perhaps that was a piece of the opposition.
Okay, thank you for bringing this bill, Delegate Dumais.
Sure.
The Vice Chair.
Thank you, Mr. Chair. I just wanted to say thank you to Delegate Dumais for joining the ladies in Animal Print Day today on the committee. And thank you to the ladies who did participate. I see you, you look lovely.
Well, thank you, ma'am.
Delegate Crutchfield, apologies. She looks lovely. Delegate Williams, Delegate Arakan, Delegate, where's your headband?
Oh, I see it. Lopez, right?
All right.
As always, the Judiciary Committee is a great deal of fun. And so hope you all have a nice evening. And obviously, God forbid there's questions, you know where to find me.
Yeah, when people say House Judiciary, they say fun. All right, thank you very much.
All right, thank you.
That
Bye.
concludes testimony on Delegate Dumais' Bill 744. And now we're on the last bill of the evening. House Bill 672. That's right, the last bill of the evening, 672. Delegate Attar is here. Let's see who we've got. 7 according to this. There are 5 in favor, 2 against. So we'll hear all of those in favor. It's Delegate Attar, Vince McAvoy, Shmuel Moinzada, and I apologize if I did not pronounce that correctly, City Councilman Yitzi Schleifer, and Richard Worley from the Baltimore Police Department. We'll go with them first. Delegate Attar for 3 minutes, everybody else for 2, and then we'll hear from those in opposition. All right, Delegate Attar, please, for 3 minutes.
Thank you, Mr. Chairman, members. For the record, I'm Delia Attar, and I'm pleased to present House Bill 672, Juvenile Offense Database. Several years ago, I worked as a prosecutor in the Baltimore City Juvenile Justice Center. It was an extremely emotional and eye-opening time in my career. It became clear to me that we are doing wrong by our children. Day after day, I would see children going in and out of the system like a revolving door. Our children, our future, are coming out of the juvenile system worse than when they went in. We are not properly rehabilitating these children. And this is not a new problem, and we have yet to remedy it. It also became clear to me that we are doing wrong by victims. Time and time again, I hear from victims of violent crime committed by juveniles, victims who are kept in the dark, victims who cannot get information about their case. This is not new either, and we have yet to remedy it. There's a lack of transparency in the system. How are we to ensure children are being rehabilitated if we're being kept in the dark? How are we to ensure our victims are being treated as victims when they are being kept in the dark? House Bill 672 creates a database that provides a general description of any judicial or other action taken in relation to a juvenile alleged to have committed an offense. I want to be very clear about this. It is extremely, extremely important that we protect the identity of these children. That is not up for debate. This bill expressly prohibits the database from including any identifiable information about the juvenile, including name, age group, race, address, and any known alias. It has been brought to my attention that some are concerned the information to be provided in the database can lead to the juvenile's identity. To be clear, this is not the intent of the bill. I am therefore respectfully asking this committee to work with me on this bill to ensure the possible release of the juvenile's identity is no longer a concern. We must do right by our children and our victims. We must no longer allow victims of violent crime who are already suffering so much from being victimized to be treated poorly and kept in the dark. Transparency is crucial in the process, and I therefore ask for a favorable report. As you can see in the written testimony, the bill is also supported by Senator Jill Carter, the esteemed 41st District Senator, who is a leader with regard to juvenile justice reform. I will now turn to my panel, Colonel Worley from the Baltimore Police Department, Councilman Schleifer, and Samuel Monzada. Thank you.
All right. So it should be Samuel Moanzada. All right. So got the first name completely wrong. But if I mispronounce it again, you'll tell me. That's fine.
Okay.
We'll start with you. Go ahead, sir.
All right. Thank you, Mr. Chairman. So I'm Sam Moanzada. My 7-year-old father was a victim of a brutal attack committed by several juveniles 3 months ago. On November 22nd of 2020 at around 9:30 p.m., my father got out of his car from synagogue, and moments after, one juvenile approached my father with what appeared as a gun and asked for his keys and belongings. My father struggled to hand over what was demanded due to shock, and the juveniles, I believe out of impatience, started to beat my father. My father started acting out of self-defense and then gave this juvenile a fight. And seconds later, 2 other juveniles jumped my father on his back and tackled him to the floor and started to beat him on the floor, hitting his head and ribs and grabbing his keys and wallet, and took off with his car. My mom, during the whole sequence, was screaming on the top of her lungs that one of the juveniles pointed a gun to her and told her to go inside or he'll kill her. And days later, my mom was dealing with anxiety and fear and had to take off of work because of it. She still deals with some levels of anxiety because of it, and it was a terrifying moment for her as she thought they would take his life at one point. The whole sequence of events has taken a toll on my 7-year-old father for months after, and slowly, thank God, he's starting to be himself. I would like to also, we were desperately trying to find out if those who committed this were being held accountable. Unfortunately, felt like we were being held in the dark. And then we heard that 12 out of the 13 juveniles who were involved in recent carjackings around our house were released the day after their arrest. As a victim of a violent crime, my father should not have been left in the dark. We were not asking for the identity of the juveniles. We just wanted to know what is going on and be sure there are consequences, and that these juveniles were getting the help they needed so they never commit such a crime again. This bill is exactly what victims like my father need. We are not asking for the juvenile's identity. We just want there to be transparency and victims to be treated like victims, and not like we are nobody and nothing happened to us. Thank you, Mr. Chairman, for giving me the time to testify, and please vote favorably on the bill.
Thank you very much. We'll go now to Mr. Worley from the Baltimore Police Department.
Yep. Good afternoon, Chairman Clippinger, Vice Chairman Atterbury, and members of the Judiciary Committee. Thank you for allowing me to speak to you today about House Bill 672. My name is Colonel Richard Worley. I'm the Chief of Patrol. Currently, I'm in charge of all of the Patrol Division, which includes all 9 of the districts and about 1,500 sworn personnel. Over the course of the last year or so, the Patrol Division and the Criminal Investigation Division have worked with our Public Information and Government Affairs team to consistently provide public and our elected officials with timely updates on arrests made for violent crimes such as homicides and shootings. We also started hosting monthly district commander crime and community meetings where we provide residents, faith leaders, and business leaders of each police district with crime statistics, updates on implementation of consent decree, and discuss ways in which we partner to prevent and solve crimes. These measures are a component of our wider community policing plan and designed to increase communication and engagement with our residents we serve. That being said, my commanders are oftenly and frequently asked about crimes committed by youth offenders. Often those inquiries focus on violent crimes such as carjackings, shootings, and other crimes that inflict trauma on those and severely shock the conscience of many of the neighborhoods. Just last year, 124% increase in juveniles arrested for carjackings. Not only are victims concerned about the consequences and punishment of these offenders may receive, but the residents, media, and elected officials frequently want to know if we arrested the offender, are they back on the street, how quickly they are released, and if ultimately sentenced, what punishment they received. While we can do and provide limited information about the arrest without withholding and identifying information about the youth offenders, we cannot provide updates on the other set of questions posed to us. That is why the Baltimore Police Department is supporting House Bill 672. We believe that this database will provide the public with necessary insight into crimes committed in our community. Moreover, it will allow the public to understand how juveniles are being treated by the criminal justice system, the types of sentences juveniles are receiving, and whether or not prescribed interventions are having any effect on behavior of the juvenile. The department wants to continue to work with our criminal justice partners to ensure that these offenders get the help and services they need to prevent them from being repeat offenders and receive the proper rehabilitation to help them become productive citizens. The bill expressly forbids the release of any identifying information regarding the juveniles, including his name.
Thank you very much. If you could wrap up, please.
Yeah, I'm good. Therefore, the Baltimore Police Department respectfully requests a favorable report on House Bill 672. Thank you for allowing us to comment on this piece of legislation.
Thank you very much. Let's go now to Delegate Cardin and then Delegate Please.
Thank you, Mr. Chair. Just very quickly, to Colonel Worley, it's good to see you in our offices, sort of remote, instead of in your office. I'm usually sent to the principal's office, have to talk to you with my clients, so it's great to see you here. I'm just wondering, do you guys have money for this? Do you be able to put up some money to be able to do this, or is this, how's it going to be funded?
I can answer that question. So I do see that it is a high fiscal note, and the Department of Juvenile Services said it will cost them a lot. What I would suggest is, right now the bill just says any offense. I am open to it being changed to just violent offenses, and DJS advised me that violent offenses are only 1/3 of the individuals that are in the system. So if I'm doing the math correctly, and I don't really know math, I'm a lawyer, I would say it'll cut it by maybe 1/3. It'll end up being 1/3 of the price of the fiscal note of what it is now. So that's my suggestion. I understand it is a high fiscal note, but the Department of Juvenile Services would be responsible.
Okay. All right. Thank you very much, Delegate Grammer, then Delegate Crutchfield. Delegate Grammer.
Thank you, Mr. Chair. Thanks for the bill, Delegate Attar. Several years ago, we put together the Juvenile Fatality Review Team, and I was placed on that team as the member of the House. And I agree with your sentiment 100% that we don't really serve these juveniles well. They're frequently bounced back and forth in the system and not remediated at all. Here's my question. You didn't specifically say it, but I wanted to ask what the purpose of the database would be. Is it to give some kind of transparency into a non-transparent system? What's the ultimate goal here?
Thank you. So this was started because of complaints I've been getting from victims, and what I've been seeing is happening with victims who are kept in the dark. So originally the intent of it was so victims have a place where they can get information, again, not about the juvenile's identity, but what's going on with their case. Noticed once it was drafted, and I noticed something in the courts have some opposition, that they said basically we don't want transparency because then it makes the public doesn't realize we're trying to rehabilitate. So I understand that side of it, but my concern is we are not rehabilitating them. I'm looking at the statistics now when it comes to recidivism rates provided by DLS. And in 2017, for example, it was a 67% recidivism rates within 36 months of someone being released. And it goes down a little bit from that when you shorten the amount of time. So I want this bill. I don't want this bill to lead to the identity of the juvenile. I wanted to have transparency in that we as the public, or even if it's not the general public, individuals that are not part of the juvenile system can understand what's going on and see what needs to be fixed in order to rehabilitate them. But again, the intent of the bill was primarily for victims and what victims are going through and how they're being kept in the dark. So if we need to change that a little bit, that it's for victims, I'm not opposed to that if that's what's necessary.
So in other words, you could see their case and what was done, but you necessarily couldn't see the identity of the.
Yeah, so you would be told, let's say if they're being detained, it'll say they're being detained. But yes, it wouldn't say the identity of them. It would be for the victim to know what's going on with it.
Okay, thank you.
Delegate Crutchfield.
Thank you, Mr. Chair, and thank you, Delegate Attar. I think Delegate Grammer really asked the question that I really had in mind, but I want to go on just a little bit further because I need to make sure it's coming together clearly for me. So you're saying that this bill is designed to provide data without the names, without any identifying information, but just data, right? And that somehow using that data, you have a sense that that's going to provide some insight into what's going on in various neighborhoods, or specifically with just what the children are doing. And because I guess what I'm thinking is that most of what you're looking for probably DJS has already, and can provide that, because I mean, listen, the juvenile justice system is supposed to be about rehabilitation, right? And so I do believe what you're looking for is there, but yet it seems like you're really saying more specifically, and we also heard from the gentleman that described the unfortunate circumstance with his family, which makes me even believe further that it's about really knowing what that specific crime is for, what that child did. So I'm a little concerned about that because, I agree with the court system. I agree that, this is all about rehabilitation. And when you have information that is out there that could be labeling or stigmatize children, then you are not getting to and able to really get to the point of rehabilitation. We're now punishing them because we've got that information out there and people know who they are, versus rehabilitation, which is all about making sure we fix whatever the problem is. So I guess I'm just a little bit concerned about that. And if you'll talk to that and just kind of tell me, because I'm still, it's still not pulling together for me the notion of we're going to collect this data and we're not going to have their names, but yet it sounds like the victims involved really do want that information.
So what I was understanding from victims, and when I was working in the system and speaking with victims, they were not being updated. And I know there's a lot of laws on the books right now for victims that they should be notified, but it's not working what we have right now. So I agree with you. We don't want to stigmatize them. I will say that in the bill, as it is right now, it lists that any prior offenses should be committed. I'm not opposed to that, should be included. I'm not opposed to that being removed, because my intent of the bill and what my goal is that victims have a place to go to find out what is going on with their case. Now, that doesn't necessarily need to be open to the entire public. I was discussing with the Department of Juvenile Services as specific ways that it could be done, possibly using an incident report number for a victim to search for what happened. An idea came up of, I'm sure everyone knows what Vine Link is, that people can go in there and see where the adult is, if they're being held or if they're released. Something like that the victim can put their incident number in or the location of the offense, and it'll tell them. Now, it's not going to go into a lot of details about what type of program, like let's say they're in a rehabilitation program. It's not going to say what type of program they're in. It's not going to, or where the program is. It won't say where the placement is if they're sent to a placement, but more so just to give the victim information. This victim that just spoke, he finds out in the newspaper after he keeps trying to get information, his family's trying to get information, they find out that, oh yeah, they arrested 13 of these children and 12 of them were released the next day. And in the meantime, they have nowhere to go to find out when this happened, how this happened, were any of those juveniles involved in the attacks against his father? And again, not the identities, but in general. So I understand your concern. And that's why I'm asking for the committee to work with me to alleviate those concerns. And I do believe there are possible ways, maybe take part of what's being asked in there out, like the prior offenses and anything else that we believe that could kind of alleviate those concerns. Does that make sense?
Well, Delegate Attar, to me, honestly, it's about the state's attorney's office, okay? If the victim wants to know what's going on with their case, they need to be on that state's attorney, okay? Or the victim witness section of that state's attorney's office. I do not believe that this is where that should be taking place. That's
I understand, but I will just say that I've heard from victims all over, not just my district is in Baltimore City, but not just in Baltimore City, that this is a concern of theirs, but I understand completely.
Okay, thank you.
Delegate Erican, please.
Thank you, Mr. Chair, and thank you, Delegate Attar, for this really thoughtful bill. I'm just trying to figure out, because Delegate Crutchfield raised some questions I just don't have answers to. So this information, let's say that we remove the sort of identifying information, which would probably include information about what the actual crime was, because there's not that many crimes that are of that type that take place on a certain day in a certain place. But why are they not able to get this information from the district attorney's office right now, like what Delegate Crutchfield said?
I don't know why it's not happening. I know at times it is happening. I don't know counties have the biggest issue, and I can find out, see if DLS can provide me some insight on that information. But what I can say is a lot of victims tell me we don't know where to turn to. People who know me, they call me and then I send them to the right person, whether I tell them it's go to the police department here, or someone else here. Someone reached out to me on Facebook who has no idea who I am and was just like, where am I supposed to start when I call the police department? They don't know the information. I call the state's attorney's office. I get a receptionist who says someone will call you back. It's not happening the way it probably should be happening. And victims spoken to are at a complete loss as to where they can go. I will add one more thing that I've been speaking with AS about other possibilities. They're completely open, and this is not exactly where I want to go, but they are completely open in the meantime to putting a link on their current website where victims can request information and they would have to respond within a certain amount of time. But we're not exactly sure how that can work, but that is also why I'm asking the committee to please work with me on this to make something work for the victims.
Yeah, this is a really important issue, and people that are victims of juveniles, I think, are really, really terribly mistreated in our state. So thanks for bringing this bill forward.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate Attar, for this bill. My question is, if you have 4 people that participated in an incident and 3 are adults and 1 is a juvenile, are they going to have 2 different incident or case numbers, or are they going to have the same case number?
So they're going to have different case numbers. I was referring to an incident number. I don't know if it will work to put the complaint number from the police department, and I'm not sure how every county does it. I know in Baltimore City, there's a CC number, and from one incident, they'll all be connected. But a juvenile case number is different than an adult case number. The incidents for the adults, those are public already, so we wouldn't even be worrying about those 3 cases.
Thank you very much.
Delegate Cham.
Thank you, Chairman, Vice Chair, and members of the committee. I have just a couple of questions. One is very simple. Are there any other states that are going down this path to collect these kinds of data? And my second question is, what information would the juvenile be seeking that they don't already know since they were involved in the crimes they committed? I'm sorry, that may be very, very, very basic. I apologize if it's too simplistic, but if they're seeking information, what is it that they need that they don't already know because they were involved in some criminal activity?
Oh, so are you asking what the victim is seeking to find out? Because this is for the victim. I believe you asked what the juvenile is seeking.
Okay, so when you said
the
person that was, the crime was committed against.
Yes, exactly.
They are seeking information, their case.
Absolutely, yes. That's
okay. Thank you for that clarification.
You're welcome. And as an answer to your first question, I have requested that. I don't have the answer as to if other states are going down this path. I will follow up on that and let you know.
Okay, thank you, Delegate.
Sure.
One of the witnesses, we missed him initially. We're going to let him talk now. As City Councilman Yitzi Schleifer is here. He's here, and we're going to give him 2 minutes to speak. We'll take any questions to him, and then we'll go to the opponents. So let's go ahead. Councilman, go ahead.
Thank you very much, Chairman Clippinger and committee, for allowing me the opportunity to testify on this bill.
I'm certainly glad I'm not driving around Annapolis looking for parking right now. So this is quite the format. So we all know that juvenile crime is an issue that is only getting worse. Anyone who has spent the time that I have on studying this issue comes to a clear conclusion that the adequate resources are not being provided to rehabilitate these children like the system is dictated to do. When it comes to adults, we can see and measure the success of programs like we have in Baltimore City, like ROCA. But when it comes to the underfunded juvenile system, we, the taxpayers, have no idea what happens other than that we see the same, or we hear that the same juveniles continuously reoffend. We know that the best time to course correct is before these kids become adults and have a permanent damaging record. And so bringing transparency to what's working and what's not working in the system without compromising the identity of the juveniles is a win-win to protect the futures of these children and the overall public safety. So thank you so much for the opportunity to testify.
Okay, Delegate Grammer with a question for the councilman.
Hi, Councilman. Thanks for coming. So in my district, when we see these juvenile cases, frequently we'll know who the youth is, we'll know his name, we'll know where he lives. We know pretty much everything about it because usually people are sharing information, trying to figure out what happens with a crime, and then it gets sent into the system. And frequently we'll know that that youth will be back out on the street the same day. And we're kind of left asking what happened. And in a lot of cases, they reoffend, go back in, out, and we're kind of blind. And I just wanted to ask if you can elaborate. You know, I represent the county, and I wanted to see if you could articulate a little bit about your experiences in the city, see similar things. I think I understand what you're experiencing, but I just wanted to ask that firsthand of you.
Thank you, Delegate. And I'm not sure how people's information are let out. I know, at least on the city side, I've not seen juveniles' identity be released, or where they live, or who they are, or what school they go to, or any identifying information. So I'm not sure how that's happening in other jurisdictions. And if that is happening, certainly somebody's releasing that information who's not supposed to be doing that, because that is certainly a concern for those juveniles. However, what I'm seeing in Baltimore City is that we do hear, you know, the same juveniles being let out time and time again. And what I'm hearing as a councilman now from parents of these children is that they don't have the resources themselves to deal with their child. They love their child, they want what's best for their child, but they are relying on the system to help them course correct their child. And so I had coffee with a mother who reached out to me when I started talking about this proposal on the radio a couple years ago. And she asked if we could meet, and we went out for coffee and we were discussing it. And she was talking about how she would call constantly, trying to find out what was going on with her son. There were certain things that were put in his program which were not being followed. And just because he had an ankle bracelet on, he was still doing the same crimes, and he was still dealing drugs. And she was trying to get him the help that she needed. She just felt hopeless, you know, and she did everything she could to protect her child and to help get him on the right path. And unfortunately, now her child is no longer with us. And she blames the system for that and says that had there been more awareness about what was going on, and there been more awareness about what the programs are and what each kid, depending on the crime they commit, is experiencing, then we know what works and what's not working. And so we know certain rehabilitation programs work very well. But what I could tell you is very clear is that most kids are not afforded that opportunity. And it would not surprise me one bit if money was playing a role in that perhaps the system's not giving these children the resources they need simply because of money. I see that taking place when it comes to special services for children in schools who have learning disabilities or other challenges. Oftentimes those services are not being provided to those kids who need help because of the cost of those services. And when it comes to crime, we know it's far more costly on the back end than it is in dealing with it on the front end. And if we can give these children the resources they need and show them a better path forward, we would not be experiencing the same issues over and over and over again. And so this is actually something that, if it's shaped correctly, and whatever recommendations the committee has to shape it, is certainly very, very useful. This will be a game changer in changing the lives of these juveniles.
So her son died.
Correct.
Okay, so that was one of the cases that I don't know if you caught the front end of the conversation, but I'm on the fatality review team, and every time someone dies in the custody or in the system, I review all those cases.
And they didn't die in the system. I'm sorry if that.
Okay. Well, they're involved in the justice system, and they end up getting shot or whatever. And this, I think I sense your disconnect here, because the juvenile system actually documents all the resources that they give these kids. If there's a placement, if there's mediation, if there's mental health treatment. So Mr. Chair, I actually do agree that there is a disconnect here between families, between the system, between victims. So I don't, I think this conversation is a good start to that. And I think what you're saying here is very legitimate, and I appreciate you coming.
Okay, I don't see any further questions. And so with that, we thank you all very much for testifying today in favor of House Bill 672. We appear to have just one person in opposition to 672, and that is David Shapiro. And I believe he is connecting now. Mr. Shapiro. David Shapiro?
Yes, thank you.
There he is. For 2 minutes, please.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. My name is David Shapiro, and I'm an assistant public defender in Baltimore City. We urge an unfavorable report on House Bill 672. Our written commentary tackles why we continue to need confidentiality in our juvenile court system. It notes crucial flaws in HB 672's language, including what offense might mean, as well as that prosecutors are to effectively communicate with victims already by statute. We will always support evidence-based legislation that serves our client population, and unfortunately, this bill misses the mark. Our juvenile justice system intentionally shields respondents from the public eye. What a child does shouldn't follow them for the rest of their lives and shouldn't define them. This bill would create a central database for all to see without any context. If you ever read the online comments to a Baltimore Sun Facebook post or to an incident in the Citizen app, you already know that this won't encourage people to band together to offer quality programming to children and teenagers throughout the state. The responses to crimes online and in social media are visceral, disgusting, and racist. We can imagine the Facebook groups that would be generated from such a database. Individuals not only engaging in racist diatribes, but perhaps seeking to engage in vigilante justice, in violence. I'd love to see a bill that is a database of all the great deeds my clients and the young people of this state do, taking care of their siblings while their parents hold down multiple jobs, volunteering at food banks when they themselves have little to eat at home, a database of greatness of our state's young people. In my work as an assistant public defender, I'm also our office's point person for juvenile expungements. I have come to understand firsthand that unfortunately, acts committed as a young person are impossible to break free of. I've had young adults who come to me with no fact-sustained findings. I've had individuals who didn't do what they were accused of, and they face barriers to employment, joining the military, and the law as it stands makes it an arduous process to even attempt to remedy these issues. We look forward to working with members of this committee to improve many aspects of the juvenile court system, but particularly confidentiality aspects. We want to help you promote the success of all Marylanders. We'd remind you that this doesn't sound like data to us. This sounds like it's incidents, that it's incidental information, and it doesn't seem to do what the purpose is of this law, which would be to basically share information. So we would urge an unfavorable report, and I'm happy to answer any questions. Thank you.
Thank you very much. The Vice Chair.
Thank you, Mr. Chair, and thank you, Mr. Shapiro, for being here. Just a quick question. So Delegate Attar mentioned that the legislation would not have any identifying information related to the juvenile. So no names, not where the juvenile goes to school, where they live, nothing like that. So I'm wondering, you mentioned confidentiality was a big thing, so I'm not sure if you knew that or heard that, or what are your thoughts on that? And then also, what if the legislation was just available to the victim and the family, or the legal guardian or whatever of the juvenile? Would you still be opposed?
So yes, to answer the first part of your question, this confidentiality, it really is a slippery slope where these young people, people hear about their crimes through the media, through social media, through the, as I said, the Citizen app, through neighborhood Facebook groups. And I've seen in my investigations of crimes and representing my clients that names of juveniles, of children are shared. And so this does actually get out. And I think that the more we have a centralized database, a place where this all will be stored, the more that's likely to happen. And of course, we're hearing that happening in other jurisdictions. When Councilman Schleifer is talking about knowing about multiple kids engaging in these activities, that's not something that he's supposed to know about. He is not a part of this juvenile justice system. He's not an attorney in the system. So this is supposed to be kept confidential. I don't think that, Vice Chair, those remedies would be sufficient to get to what we are trying to solve. If the victims want information about their cases, the problem seems to be that the assistant state's attorneys are not communicating that information. And it shouldn't be that we should be throwing more money at a system which then doesn't provide any, allegedly, identifying information and only seems to provide perhaps what's in a police report online. It would not at all share any information about who this young person is as a person. And therefore, I don't see how it would show if the system is even working. We have a lot of data, real data, provided by the Department of Juvenile Services that tells us how placements work, recidivism rates of particular placements, by race, by age, by gender.
I just want to cut you off.
Like,
Thank you. Thanks. One follow-up question. So, and I mean, I appreciate the comments on, the social media and everything. I believe all that. I believe people go crazy and lose their minds on social media. So, question, what I found interesting, because I didn't see it from this perspective, the way it was presented, but the councilman talked about someone's family member, a mother who was actually in the system, and she was having problems finding out what was going on with her son, and she couldn't connect to anybody in the system. So how would you propose to resolve that? Because the delegate suggesting that this would help those families as well, so victims and people in the system.
Yes, and I just don't see how they can't reach out to, there are state's attorneys they can reach out to, and of course there are public defenders like myself. We represent their children, but of course we're in constant communication with the families. I don't think that this bill solves that kind of terrible miscommunication. We have a lot of parents that believe the system is not providing the resources that their kids need. What that means is we need better programs. We just got this past year, I believe, MST for the first time again, multisystemic therapy in Baltimore City. That's an evidence-based program. And before that, our only other evidence-based therapeutic program was family functional therapy. We need more programs like that, that's for sure. But the solution is to give money to those programs and to provide them also before the kids enter the system, rather than create a database which doesn't have any identifying information, assuming a parent can access, I guess, the internet to access that information, and that it would somehow tell the parent basically where the kid is or what the court dates are, which they should already know.
Okay.
Thank you.
Thank you, Mr. Chair.
Delegate Grammer.
Thank you, Mr. Chair. I'll try and be brief. Thanks, Mr. Shapiro. So you closed your last comment saying, they don't get sufficient resources. We need better programs. I don't know if you know that, because that information is shielded. How, and the sad part of the entire system that I found over 2 or 3 years now is that frequently everything the juvenile system does is documented, and you'll see a case that will last 6 years. and they'll go through a thorough review. And, you know, sometimes it's about working with the courts. Sometimes the courts don't respond for some reason. Sometimes it's about working with the education system. And frequently the juvenile system is, you know, they have problems with the education system or vice versa. And the reality is you don't have any information to base that off of. And the people on this committee would be shocked to see some of the things that I see in the system. So I'm really struggling when people say like, we're not doing these kids a service. That is 100% true. And the real problem is nobody really has an objective way to see anything about any of these kids' files, except the 6 people, you know, that can see everything. And the frustration is when us 6 people are on that call, you know, talking about this poor kid that's died, that's where that information dies. I mean, that's it. It's just us 6 and nobody else in the world can see that. And I don't know if this bill's perfect, but damn, she really has a point here. The other people on this committee should really see some of this information, and so should you. And that way, when you say these kids aren't getting resources, that's not always true. So can you tell me how you see that, you know, specifically the system is not serving these kids? Like, what do you base that off of? Objective.
Yes, respectfully, I do base it off of the programs that are available, whether they are evidence-based. We do have objective measures to determine whether a program is effective. We have social scientist researchers who research different types of therapeutic programs. For example, ROCA is consistently a program, although it's quite new, that is actually used now in at least Baltimore City. And that has been researched multiple times. But we don't have many programs like that.
How do you research it if you can't see information from the system? You can't see statistics. You certainly can't see individual files.
We're not able to see. I guess I'm not sure what you mean by that.
You say researching, and that would require an examination of the totality of the system. And if you can't see anything, how are you researching this? We can't even research it.
I guess I'm not understanding your question. We can research and evaluate how effective programs are. And so we might not be able to see if it's going to definitely serve an individual particular youth, but I'm not sure how this bill, how this database would get us there. Nor do I see why, with a lack of funding and with additional evidence-based programs, we would get there.
All right, I appreciate the question.
All right, seeing no further questions for the panel, for the person, except the vice chair just popped on.
Sorry.
That's all right.
Thank you, Mr. Chair. Quick question from Delegate Attar. I may have missed it. I'm sorry. Did your city delegation take this up or discuss this?
No, it's a statewide bill.
Okay.
Yeah, they won't.
You mentioned that Senator Carter supported it. So I was just wondering.
Yeah, I sent the testimony today. I sent 3, I believe it was emailed to everyone in the committee.
Okay.
Not, it was written testimony from her. Her and I were working and discussing it because there were recent carjackings in our district, a lot of them, and we got a lot of victim complaints. So that's why I mentioned her.
Yeah, there is a letter in the file, just for the record. There's a letter in the file from Senator Jill Carter in support of the bill. Okay, seeing no further questions. Thank you all very much. And that concludes today's testimony, including the testimony on House Bill 672, concludes the testimony today for the House Judiciary Committee. We will be back tomorrow at 1:30 for further legislation, and we will see you then. Thank you very much.